Welcome back to the Hexen Podcast, where we take marketing to the power of X. Joining us again today is Chris Combs and Steve Waterkotte from Combs Waterkotte, a law firm located in Clayton, Missouri. We're going to talk today about domestic violence, which is a sensitive subject, which is, I'm sure, difficult for a lot of people to even discuss. So in the sense of being on the other side of things, what should I do if I'm accused of domestic violence?
First thing, if you're arrested for domestic violence, that's typically how these things start. A phone call to police by a husband and wife. Do not speak to the police. Do not incriminate yourself. Exercise your Fifth Amendment right, which you have the constitutional right to do that. And so that'd be the first step. And second step would be get an attorney. You know, anytime you're accused of something serious like this, it'd be wise to do both of those. Do not talk to the police, exercise your Fifth Amendment right, and get an attorney ASAP.
Can I be arrested if I'm accused for domestic violence without any evidence?
Yes. You know, a lot of times folks think there's got to be physical markings, and those certainly will almost always lead to an arrest, and that's strong evidence that can be used, of course, against somebody accused of this. However, in many of these cases, there are no physical markings. You know, if you're grabbing somebody, choking is a common one. You know, a lot of times that doesn't necessarily leave marks, so that, you know, there could be an accusation. You know, he choked me, she choked me. Pushes, you know, he shoved me, pushed me up against the wall. He didn't allow me to leave. You know, he kind of held me against my will. All those instances, all those accusations aren't allegations that necessarily leave markings, bruising, things like that. And so it is not uncommon to be arrested for a domestic assault charge without any physical evidence based on the word of the accuser.
How do I prove my innocence if I'm accused of domestic violence?
Well, number one, it needs to be said that you do not have to prove your innocence. The burden of proof always rests entirely on the state of Missouri against the prosecutor. So they have to prove that you, in fact, did what you're accused of beyond a reasonable doubt. So the phrase, you know, any defense lawyer will immediately correct that, is that, you know, we have no obligation to prove that our client was innocent. They have the obligation, the state, the prosecutor has the obligation to prove our client did it beyond a reasonable doubt. Now, that said, we don't just sit there on our hands and do nothing. You know, we do an investigation. We speak with our client about what took place, what didn't take place, our available defenses. Is this a self-defense case? You know, a lot of the times domestic assault turns into that. You know, a viable defense is self-defense in this area. And so we do all those things to help raise reasonable doubt or to help aid in getting a better plea offer. You know, we do our investigation. That could come in the form of text messages, and there's history of this or prior calls to police. There's a number of different things that we will work collaboratively with our client to obtain. So we ultimately are going to the prosecutor and saying, hold up, you know, this isn't what this case looks to be. Let me show you X, Y, and Z, which could debunk these allegations or refute them, prove them to be false. So we never have an obligation to prove our client didn't do it. However, we will do a lot of things, investigation, working collaboratively with our client to help refute these, to help show that they're false or that the accuser is not credible.
And a lot of this is challenged in these turn-on depositions as well, which is taking the alleged victim's sworn statement and challenging, you know, truthfulness, veracity, credibility, timeline, you know, et cetera, et cetera.
So what are the penalties for domestic violence?
Well, you've got domestic assault fourth, which is a Class A misdemeanor, which is an interesting one because the statute just reads putting someone in the immediate apprehension of physical harm. Typically a shove or a push is going to be involved, but there's nothing in that law that says you have to touch anyone. And then it goes up from there to a Class E felony, which means that there is some physical injury. Then a D felony is serious physical injury, and then it gets all the way up to a B felony or an A felony, depending on the severity of the injury, among other things.
So there's a big range, as you can see, and there's a lot of discretion. Police officers make the arrest. They turn it over to a prosecutor who issues charges. So it's important to know that distinction. Police make arrests, do their investigation. They turn it to a prosecutor. So a prosecutor has, if there's 4, domestic assault 1, 2, 3, and 4, that's a range, quite a bit of a range there. And a prosecutor has a lot of discretion in which to charge these. And that's sometimes our defense is that, hey, this thing was overcharged. We're not, there's times in our defense is, yeah, our client did it, but he didn't, this thing's overcharged. This falls more under domestic assault 4th rather than a 3rd in which you're charging, which that's a big jump because you're going from 4th as a misdemeanor. And anytime you go jump into the felony, that's a big difference in terms of, not only penalties, but background if you take a conviction and things like that. So the prosecutor has a lot of discretion at his or her hands when they charge these.
How do I get domestic violence charges dropped?
There's a number of ways we do that. A lot of these cases are, husband, wives, boyfriends, girlfriends, where, it's one bad night, So there's times when the alleged victim decides they don't want to prosecute. We'll get an affidavit of non-prosecution, present that to the state, the prosecutor. Doesn't mean the case is going away.
Right.
Typically they'll see if they can make the case without the alleged victim. Oftentimes we'll then set it for trial. That is one way we get a lot of these dismissed. If the alleged victim is full bore wanting to prosecute, that's when we go back to like what Steve said and doing a full-blown investigation on who is this alleged victim, what does their history look like, and then, depositions, challenging them on their version of events, their truthfulness, things of that nature.
So what happens during a domestic violence investigation?
Police typically show up, usually in the immediate aftermath. That's how these typically begin. Somebody or neighbor or loved one in the home calls the police. Hey, mom and dad are fighting. I hear the neighbor fighting, things like that. Police show up. You'd be surprised by how often they only take one side of the story. Sometimes it could be a race to who calls and who talks to the police first. Sometimes it's a mutual combat. I mean, a mutual fight where both parties are engaged, and yet, one may call, and sometimes it could be a race to who gets their, who kind of paints the narrative first, right? And so you'd be surprised by how often they only speak to one party, and if you're being accused, as I said, it'd be wise not to make a statement. If you had somebody call, hey, Steve is hitting me and beating on me, and they show up, the picture's already painted, so to speak. At that point, you're probably not going to do yourself any favors by talking to the police. Well, yeah, I did it because of this. You'll see things like that. Well, that incriminates you. So if it's a situation like that, the wise thing to do is not give a statement or answer questions. But again, you'd be surprised by how often police don't even ask that other side of the story or give that person an opportunity to even allow them to exercise their Fifth Amendment right. They take the statement of the accuser. Okay, that's enough. Let's make our arrest. Let's lock them up or issue them a citation or summons to appear in court, and off we go.
How important is it to hire an attorney when you're accused of domestic violence?
I mean, as important as any other area of the law. Domestic violence charges are some of the few you can never get expunged. So it is critical that these are handled properly. Again, they cannot be expunged. As Steve said, broad discretion by the prosecutor, so you could be looking all the way at an A or B felony down to a misdemeanor. But again, the connotation the stigma behind domestic, violence and domestic assault, it's so critical to make every effort to either get the charge amended to something different and or a dismissal.
And by dismissal, it's like dropping the charges, right?
Correct. And the prosecutor only has that ability to do that. Nobody else. Judge can't. A limited circumstances after a preliminary hearing or something to that effect. But by and large, the prosecutor holds that card, and only they can file dismissal of the charges.
What are my rights if I'm accused of domestic violence?
Fifth Amendment right, your right not to talk or answer questions. And so that's, and then of course you have a right to an attorney. You have the presumption of innocence. We all have that right in this country, right to a trial. So you have all your constitutional rights come along with it. But the one in this area that's critical to follow, and it's almost always applicable in these cases, is your right against self-incrimination, your Fifth Amendment right not to answer questions. And a jury down the road cannot make any inferences based on your decision at the time of the investigation to say, hey, listen, I'm not speaking with you without an attorney. I'm not waiving my Miranda rights. I'm not answering your questions. A jury at a trial cannot hear about that. Therefore, they cannot make any inferences against you for that.
I think another important thing to note that I see a lot is someone gets arrested for domestic assault. They're in jail. Who's the first person they're going to call typically? If they think there's any way of trying to make things better, they're calling their accuser, correct? Yeah. Well, what they don't realize is the second they've been arrested, there's a court order of no contact with the alleged victim. So domestic violence prosecutors love going to the jail calls to see if they've tried to persuade this person to drop charges. Here comes another felony, tampering with the witness in a felony prosecution. And then sometimes, I have clients say, I didn't know I couldn't talk to her. So that's something I think is important to get out there informational-wise.
I ditto that, and that's critical. In St. Louis County, they will routinely, on felony domestic assault charges, use their resources, their investigators and prosecutors themselves will listen to those jail calls, like Chris said, because one of the first calls in somebody locked up will be to try, in many cases, to call their accuser, the alleged victim, to try to get them to dismiss the charges. And so it's critical that folks know that every call in that jail is recorded and listened to, except with your lawyer. And even I don't feel completely comfortable, and I think most lawyers would agree with me here. We don't ever go into the facts of the case over the phone. I just don't have that much trust in the government, frankly. There's prosecutors. I've had a prosecutor say, I was listening to these calls, which they're allowed to do by law. And we always tell our clients, listen, every call is recorded. Use caution. If you want to talk about, hiring a lawyer, when your court date is, how's my baby doing, how's grandma doing, all fine. But do not get in the facts and the substance of this case over the phone. And I've had a prosecutor say, I was listening to calls and I heard them call you. I immediately hung up. And I trust the prosecutors, the ones in St. Louis County. But we never get into the facts. We're never going to be on a phone call saying, let's walk through what happened. We'll do that in person at the jail if they're locked up at the appropriate time. But that is a critical one, as Chris said, is that know that all those phone calls are recorded and they are listened to. And even in a big county with tons of cases like St. Louis County, they still will use resources, investigators, and prosecutors themselves that will listen to those calls.
Wow.
And you would be surprised how many times a defendant incriminates himself. I didn't mean to do it. I just got, things got crazy. Well, that's incriminating, right? You're essentially kind of acknowledging your participation, at least to some extent, into this.
And then the second you get charged with domestic violence, your accuser, the alleged victim, is going to get a call from the prosecutor. They're going to advise, they want them to hang on and to prosecute. They're also going to get a call from a victim advocate. They're going to be encouraging to file an order of protection, also known as a restraining order in Missouri. So, again, right away, there's going to be a lot of hands on the alleged victim to, this is what you ought to do, this is what you ought to do.
Wow. About how long does a domestic violence case generally take?
I mean, it depends. First off, obviously if you get to a domestic assault first degree, the more serious, typically the cases take longer to resolve versus a misdemeanor. But, you can ballpark 6 months minimum to a year, and even beyond when you get into some, I have a couple right now that are approaching a year, domestic assault first degrees. So the more serious the case, the longer it's probably going to take to resolve. 6 months to a year is kind of a ballpark, but certainly can go longer than that the more serious it is.
And we never want to rush a case at the expense of the outcome. Now, of course, if a client is incarcerated, we're going to speed things up. But we've done so many of these that I've only seen things either stay the same or get better with time. So, again, while 6 to 12 months is a good ballpark, I often tell clients, look, I know you don't want this hanging over your head forever, but the more time that goes on, almost always the better.
Can I be fired based on a domestic violence allegation?
Yeah, and that's absolutely. I mean, and that's an employment, probably a more employment area of law, but most employers are at will, which means you can be fired for any reason. They don't like your socks, hey, get out of here. So certainly
right to work
the stigma too. I mean, that's this area of law, domestic violence, domestic assaults, probably outside of child sex crimes is probably the biggest stigma. That you are an abuser, particularly for a male, you're hitting on a woman. That stigma there is real. And why would an employer, want that person, whether it's just an allegation or not? The presumption of innocence and your constitutional rights don't necessarily flow into your workplace. An allegation alone can be sufficient. And so, again, another reason why it's important to get an attorney who is experienced in this area of law from the jump, to put yourself in the best possible position.
What do I do about child custody in domestic violence cases?
Well, that's typically a family law question, and we usually will help navigate that. But at the end of the day, we don't do family law. How a domestic assault charge could come into effect is through orders of protection, which then can affect your custody rights, right? And then, obviously, if you have a divorce pending or it is, some sort of custody order, you'll see the victim, file a modification of that based on, hey, he's got a violent history, and we'll refer folks to family lawyers that we know and trust. A lot of times we'll work kind of in side by side to while they're handling the family law case, we're handling the criminal law case, but we want to make sure our client's supported and has the resources in place for not only the criminal case, but make sure, because that's a major thing, your rights to your children and how often you can see them or visit them and things like that. And so it's more of a family law question, although it does kind of have some overlap into our area, and we make sure, we have a handful of family law attorneys that we refer cases to that we know do good work for our clients, and we'll work, kind of in conjunction with them, keep each other apprised of what's going on in each other's cases to make sure we're putting our client in the best possible position.
What's the difference between a misdemeanor and a felony in a domestic violence charge?
Well, we kind of discussed that a little bit earlier, but again, the misdemeanor typically comes with a shove, no injury for a misdemeanor. You cannot cause injury. The second you cause an injury, it is a felony, because the difference between a Class A misdemeanor and a Class C felony is creating a physical injury. So again, like I mentioned earlier, although a domestic assault fourth is typically going to have a shove or something, the way the law reads, putting someone in the immediate fear or apprehension of physical harm. So there's nothing in the law about touching. But again, almost always there's a shove or something like that. But then it escalates to a felony if there's an injury.
So what should I do if I'm accused of domestic violence?
Be quiet, exercise your Fifth Amendment right, call an attorney ASAP.
How should I avoid being accused of domestic violence?
Well, I don't know if you can ever truly, I mean, you could, obvious common sense says, hey, remove yourself from situations that could be volatile. If you have an argument heating up, I mean, these are kind of common sense approach to anything, really, any kind of conflict, particularly in the domestic where there's emotions and children perhaps involved, but is to remove yourself is the best. To don't put yourself in a position where she is making or he is making an accusation against you. That said, sometimes that's impossible, or it's just you can't do it, right? You can't completely control whether or not somebody's going to make an accusation or whether it's going to be a false one or an embellished one. The easiest way, again, is to remove yourself from a volatile situation, where you see things are starting to head towards a more hostile, violent ending.
Now, see how these kind of overlap with restraining orders, orders of protection, domestic violence. So how does that all kind of weave in together?
Almost every domestic assault case, I say almost, the vast majority, I'll say, the domestic assault cases will also lead to an order of protection.
And that's because of what I said earlier. The first call that the victim's going to get, alleged victim's going to get, is from a prosecutor and a victim advocate that's going to encourage them and walk them through the steps to file an order of protection.
And likely the police officer on scene also said that same thing.
So that's three people.
Hey, also we'll do the police report, but you need to file for an order of protection. Almost every officer is gonna broach that subject with them. So again, almost every domestic assault client of ours, the vast majority of them also have a pending order of protection case. Fortunately, we can handle that. Both charge. The criminal case and the order of protection case at Combs Waterkotte.
And how does this blend in as well with emotional abuse? So you go to domestic violence and there's no physical contact. So is it domestic violence if it's emotional abuse? That
kind of tends to fall more under what we would consider harassment.
Okay.
And that's an element of under the harassment statute, which I guess, it can be labeled a kind of a form of abuse. But the crime in Missouri for emotional distress, substantial emotional distress, is kind of what it's defined as, and so that would be more of harassment. Certainly a form of abuse, but it doesn't necessarily fall under the domestic abuse statutes 1st through 4th, falls more under harassment, which one of the elements of the harassment statute is it caused somebody emotional distress.
What is the impact of domestic violence charges on my record?
Again, I mean, they're lifelong. It is one of the, handful of crimes that, and there's not a terribly long list, but domestic violence is there's a lot of it out there. And we talked about the negative stigma with it, but it follows you around forever. You can't get the arrest record expunged. And again, but for a dismissal or an amendment to a different, like if it's a domestic assault 4th, we can get it down to a peace disturbance, go back and get that record expunged. But any type of guilty plea entered in a domestic case, even if you avoid the conviction, you enter a guilty plea, there's no going back and getting that expunged. So it will hang around for the rest of your life.
Can I defend myself against false allegations?
Absolutely.
That's a lot of what we see too.
And that's what our role is as an attorney, is to make sure we're doing our job. We're doing a thorough investigation. We're combing through some potential physical evidence, which can come in the form of text messages, recordings. And so those evidentiary issues often present themselves in these cases. Somebody has a recording that could debunk what this complaining witness or accuser is saying. It's fairly common. That has text messages, So we're doing a thorough investigation. We're collecting and accumulating any kind of physical evidence in the form of, a lot of it, like I said, is text messages and recordings and past history. The alleged victim's mental health history sometimes comes into play. And so we are leaving no stone unturned to make sure we're presenting our client's narrative on their behalf to a prosecutor to show, hey, this case isn't cracked up to what you think it is. There's much more than the surface level what this police investigation did. Here's a whole history, or here's the petitioner's history. Maybe it's a violent history, mental health history. Here's physical evidence that refutes these allegations or shows that these have been embellished. And so that's our job as the attorney, to make sure we're doing all those things, leaving no stone unturned.
So what should I expect in court during a domestic violence case?
Well, at a trial, if you go to court throughout these proceedings, you have a preliminary hearing. Typically you don't in this sense. These cases frequently get sent to a grand jury. And if there's an indictment issued, you go to circuit court and you have a trial. Typically these are jury tried cases. If you get that far, where you have 12 jurors ultimately deciding whether you're guilty or not guilty, questions that we have to kind of sort out amongst our office and with our client is whether our client is going to testify or not. That's always a big question in a case like this. Perhaps if it's self-defense, we'd almost always have our client testify. And so those are some of the questions that we are figuring out on our end as we're representing our client along the way. Ultimately, which could end in a trial where 12 jurors are deciding whether our client is guilty or not guilty.
As I stated when we started this conversation, it's a sensitive subject for many, many, many people on both sides, either falsely alleged or the recipient of any kind of domestic abuse or harm. And it's the last thing we want anyone to ever have to endure in their lives. I believe that, and I know you guys
of course
share that same opinion. And it's important to understand that going at this alone is dangerous. Without an attorney, without protection, without armed with someone who can facilitate through the law to protect you from allegations, let's say, weren't true, or let's say you're the victim and these allegations that you're proposing, well, you need support to protect the interests of those allegations so that person can never do that again. So it's really nice to sit down with you guys and discuss more in depth the details of what to do and how to handle situations with regards to domestic violence. So we'll see you next time with Combs and Waterkotte out of Clayton, Missouri. Thanks, guys, for coming in. We really appreciate it.
Thank you. Enjoyed it.
Yep. Thank you, sir.